Good morning. We are Group 8. Myself, Sanchana, Sailesh, Sandra, and Shivaraman. We are here to present you the topics. Institutional structure of WTO will be presented by myself, Sanchana. Sailesh will be presenting transition of GATT to WTO. Sandra will be presenting India and WTO contemporary developments. Shivaraman will be presenting dispute settlement mechanism of WTO, a critique. Institutional structure of WTO. Overview, WTO, institutional structure of WTO, role and functions, and conclusion. WTO. The World Trade Organization, WTO, is the only international trade organization dealing with the global rules of trade. So, hence, its main function is to ensure the trade flows as smoothly, predictably, and freely as possible. The World Trade Organization has a complex and nuanced institutional structure designed to manage and facilitate international trade and to resolve dispute among the member countries. Location is Geneva, Switzerland, established 1st January 1995, created by the Uruguay round of negotiations. It is considered to be the very important round, and membership 164 member countries representing 98% of the world trade. Budget 197 million. Secretary staff 624, and the head is a director general. Here you can see the institutional structure of WTO. It is the Ministerial Conference, General Council, Council for Trade and Goods, Council for Trade-related aspects of intellectual property rights, Council for Trade and Services, Trade Negotiations Committee, and the appellate body, very important body, dispute settlement panels, and the committees on trade and financial services, and specific committees on agriculture, anti-dumping practices, custom valuation, and etc. Committees on trade and environment, general councils on trade policy review body, and dispute settlement body are considered to be the most important councils and committees. Moving on to the ministerial conference. It is the highest decision-making body meeting every 2 years, comprising of representatives from all member countries. So the frequency of the meeting, they meet every 2 years, and the composition comprises of the WTO members who are part of the member countries. Functions: setting the WTO agenda, very important function which defines the organization priorities and work program. Decision making function, which is important to resolve trade related disputes and everything. Reviewing WTO operations. So, the performance and making necessary adjustments to WTO, providing political guidelines, offers direction to trade policy and negotiation of ministerial conference. Conference outcomes, declarations, decisions, ministerial decisions. Notable ministerial conferences which happened at Doha Ministerial Conference 2001, launched a Doha Development Round. The Bali Ministerial Conference 2013, it achieved a package of decisions including trade facilitation agreements. Nairobi Ministerial Conference 2015 focused on development of LDC issues. Then the AIRS Ministerial Conference 2017 emphasized on digital trade and investment, and Geneva Ministerial Conference 2022 addressed the pressing global trade challenges. And the Ministerial Conference plays a crucial role in shaping the WTO's agenda and promoting international cooperation on trade issues. The General Council, the main decision-making body of the entire WTO and responsible for implementation of ministerial conferences decisions and overseeing WTO operations. Composition: representatives from all WTO member countries, typically ambassadors or permanent representatives of WTO, are a part of the committee. Functions: implementation, oversees the implementation of ministerial conference and decisions and the WTO agreements. So General Council oversees the Ministerial Council's decisions and decision making, makes decisions on WTO operations including budget, finance, appointment, etc. And oversight of monitors of WTO committees, councils, and working groups. Coordination ensures the coherence among WTO bodies and activities. Preparation prepares for ministerial conference and other higher level events. Meetings. So this is very important where regular sessions typically every 2 to 3 months, special sessions as needed to address urgent issues. Hence, decision making process. Consensus based decisions are made by consensus whenever possible, and voting, a decision made by voting by simple majority or by two-thirds majority, depending on the issue. And subordinate bodies. The General Council oversees several subordinate bodies, including councils of goods services, TRIPS as such, committees on trade development, market access, working groups, and negotiating groups. The General Council plays a very important role in WTO daily operations, ensuring the effectiveness, implementation of WTO agreements and decisions, and preparing for ministerial conferences. The most important dispute settlement body of WTO, it is responsible for resolving trade disputes between member countries. The dispute settlement body of the World Trade Organization is a vital mechanism for resolving trade disputes between WTO member countries. So here are some key aspects, key functions. Dispute settlement, panel establishment, appellate review, monitoring, implementation. So the dispute settlement body tries to settle the disputes between the WTO agreements and establishes panels to examine the disputes and make recommendations, and it tries to hear the matters and appeal the matters to the panel discussions, and the member countries implement DSB decisions as per the WTO monitoring guides. Dispute settlement process, it happens through consultations, panel request, panel report, appellate review, and DBC adoption. Notable features: independent panels, transparent process, binding decisions. These are the key notable features of WTO dispute settlement body. The panel consists of independent experts and it's chosen for their trade law expertise. Hence, no such troubles or any dispute occurs. Dispute settlement proceedings are transparent with written submissions and hearings, and it is binding on the member countries, ensuring compliance with WTO agreements. Statistics, which is being given here, is 600 disputes since establishment in 1995, and high compliance rate. Challenges and reforms are being stated below: the appellate body crisis and the reform efforts which has been taken by the WTO to settle the dispute and to address the challenges. Moving on to the trade policy review body. It is conducted regular reviews of the member countries and trade policies. The trade policy review body is a crucial component of the World Trade Organization that plays a key role in promoting transparency and accountability in global trade. Hence, the purpose of trade policy review body. So it is to enhance transparency, foster accountability, and promote cooperation, and to hold countries accountable for their trade commitments and obligations, encourage cooperation among countries, or address trade-related issues. Functions such as it conducts regular reviews of members and trade policies and practices, typically every 2 to 6 years. Then written reports are being submitted by the trade policies and practices. Oral examinations are being conducted, and chairperson's conclusion. Key features: peer review and TPRB uses of peer review process, where member countries review and comment on each other trade policies. Non-judicial, the TPRB is a non-judicial body focusing on cooperation and dialogue, and rather than promoting dispute between countries. So it tries to settle the disputes. Transparency. It tries to enhance the proceedings and documents are transparent and promoting openness and accountability. So the benefits. Since trade policy review body is there, it improves transparency, encourages cooperation among the member countries, and fosters good trade relation and supports WTO objectives. And the statistics have been given below. Over 400 reviews have been made. Moving on to the councils and committees. There are various councils under WTO, which is General Council, Trade Policy Review Body, as we just saw, Dispute Settlement Body, and now moving on to the committees. Committees on Trade Development, which focuses on the trade development, including technical assistance and capacity building. Committees on Trade Facilitation, where it tries to facilitate streamline between customs procedures to reduce trade cost. Committees on Agriculture, committees on sanitary and phytosanitary measures, committees on technical barriers to trade, committees on trade-related investment measures, committee on anti-dumping practices, committee on subsidies and countervailing measures, and various other committees. Hence, moving on to the Goods Council. We saw committees, now moving on to the council. The Goods Council is one of the three main councils of the World Trade Organization. Along with the services, councils, and intellectual property rights are a major council. So the Goods Council oversees trades in goods, monitors trade policies, and provides a forum for discussion. So where the forum for discussion is open and countries can bring in their own opinions on trade-related policies, and Goods Council. Responsibilities of Goods Council is tariff negotiations, non-tariff measures are being taken into account, trade facilitation and rules of origin, and sanitary and phytosanitary measures as mentioned, meeting of Goods Council. Regular meeting every 2 to 3 months it happens. Special sessions to address special issues and concerns might happen. Membership. All WTO members are part of Goods Council. Observers. Non-WTO members and international organizations may observe Goods Council meetings. Moving on to the intellectual property, TRIPS. So the IP Council is a subsidiary body of the World Trade Organization that oversees the implementation of the agreement on trade-related aspects of intellectual property rights. So the functions as well is listed below. Monitors TRIPS implementation, provides a forum for discussion, addresses TRIPS-related issues such as dispute waivers and TRIPS agreement issues and amendments. Responsibilities, it is responsible for patents. The council oversees the implementation of TRIPS provisions related to patents, including patentability rights and exceptions. Trademarks. The council addresses TRIPS provision related to trademark, including registration, use, and protection. Copyrights. The council monitors the implementation of TRIPS provisions related to copyright. Geographical indications, where includes wine, spirits, and agriculture products. Enforcement. The council addresses TRIPS provisions related to intellectual property enforcement, including civil, criminal, and border matters, border issues. Dispute settlement. The council plays a role in dispute settlement related to TRIPS agreement, meetings and regular meetings, which happens every 2 to 3 months. Special sessions on special issues and special concerns also takes place. Membership. All WTO members are part of the Intellectual Property Council, and observers, non-WTO members can be an observer of the council meetings as such. The Council for Trade and Services, a body within the World Trade Organization that observes an implementation of general agreements on trade in services. The council meets regularly to discuss issues related to trade and services. So liberalization in trade and services, rules and disciplines for service trade, cooperation with the other WTO bodies, technical assistance and capacity building for developing countries. The council also provides a platform for WTO members to share information, address concerns, and negotiate new commitments on service trade. The Committee on Trade and Development and the Committee on Trade and Environment are two important committees within the World Trade Organization. Committees on Trade and Development focuses on trade-related developments, which needs developing and which helps the developing and the least developed countries, aims to promote economic growth and development through trade. So the motive is to bring the developing and underdeveloped countries and give them an economic growth through the trade-related policies, and discusses issues like trade and development policies, technical assistance, and capacity building, special and differential treatment for developing countries, and trade-related aspects of development initiatives are being taken, such as Sustainable Development Goals, the SDG goals. Committee on Trade and Environment examines relationship between trade and environmental policies, seeks to promote sustainable development and environmental protection, discusses issues like trade environment measures, eco-labeling, carbon pricing, and everything. Environmental impact assessment, multilateral environment agreements, and their relationships with WTO rules. Climate change and trade, both committees play a crucial role in addressing pressing global issues and ensuring the trade policies and align with the development of the environmental objectives. The appellate body. It is the standing committee of the World Trade Organization that hears and appeals from the decisions made by WTO dispute settlement panels. Functions, hears appeals from decisions made by WTO settlement panels, reviews legal issues, examines the legal findings of the panels, but not the factual findings, issues reports, submits reports on dispute settlement body. Composition is 1.7 members appointed by DSB, sorry, 7 members appointed by the DSB for a 4-year term renewal once. Representing diverse backgrounds, members come from different countries, legal system and expertise. Independence, members are independent and impartial in serving. And procedures. The first procedure is to appeal filing. A party can appeal to a panel decision within 60 days. Written submission has to be done. Parties submit written arguments to the appellate body. Oral hearings are being taken by the appellate bodies if necessary. Reports issuance. The appellate body issues its reports usually within 60 to 90 days. Significance ensures consistency and it provides further clarity, enhances credibility. The appellate body plays a crucial role in maintaining the integrity and the effectiveness of WTO dispute settlement system, ensuring the trade dispute and resolved a fair, transparent, and predictable manner. So the dispute is settled in a fair manner. The Secretariat of the WTO is administrative organ of WTO responsible for supporting the WTO activities and member countries. Headquarters Geneva, Switzerland, and the staff is approximately 640 staff members from over 80 countries. Functions providing technical assistance and support to the member countries, organizing meetings and negotiations for WTO bodies, conducting research and analysis on trade related issues, disseminating information on WTO activities, support the dispute settlement process, and Director General. The Secretariat is headed by the Director General, who is appointed by the General Council for a renewable 4-year term. The current Director General is Nosy Konjo since March 2021. So the departments are listed below: Rules Division, Trade Policy Review Division, Market Access Division, Agriculture and Commodities Division, Service Division, Trade and Development Divisions, Technical Cooperation and Capacity Building Divisions, Dispute Settlement and Legal Affairs Division. The WTO Secretariat plays a crucial role in supporting the WTO's mission and promoting free trade practice and assisting member countries in implementing WTO agreements. So, moving on to the conclusion. The institutional structure of WTO is designed to promote fair trade. Hence, the cooperation and decision making among its member countries to have a fair trade practice between countries. It promotes cooperation, provides a platform for negotiation, and supports development. Hence, the institutional structure of WTO ensures dispute settlement and challenges are taken care of, and consensus of decision making and diverse membership and global trade complexities overall are being taken care by the institutional structure, which is the councils and the committees. WTO's institutional structure aims to promote fair, predictable, and stable global trade system while addressing the diverse need of its members. Thank you. Moving on to Sailesh.
My topic is about transition of GATT to WTO. GATT defines about general agreement of tariff and trade, and WTO refers World Trade Organization. And GATT traces in the origin to the 1944 of Bretton Woods Conference, which laid the foundation for the post-World War II financial system and established the two key institutions, namely as International Monetary Fund and World Bank. And the main object of the conference was to set a new rules and regulations for the international trade barrier system and building a new economic order to the countries over to the losses of due to the war and conflict. And this led to the creations of two important institutions, namely International Monetary Fund and International Bank of Reconstruction and Development. Namely, International Monetary Fund is known as IMF and International Bank of Reconstruction and Development known as IBRD. This conference also recommended and established the three institutions. The International Trade Organization ITO, the draft charter of ITO was concluded at the 1948 United Nations Conference on Trade and Employment, was also known as Havana Charter. But due to the failure of US Senate to ratify the charter, an ITO can never come into existence. The General Agreement on Tariff and Trade, which means GATT, which was signed on October 30, 1947 by 23 nations, was a legal agreement that aimed to reduce the tariff barriers by abolishing and decreasing the quotas, tariff, and the substitute while retaining the considerable restriction. The main and the premier goal was to lower the tariff and the trade barriers to enhance the international trade. The primary objective was to offer the common institution framework of managing international trade relations. Let us see about the principles of GATT. The principles of GATT has a non-discrimination, transparency, and the reciprocity. Let us see about non-discrimination as a first. This is embodied into two main concepts: most favored nation as a MFN and national treatment, and another one. MFN means that any favorable trading terms offered to one country must to be offered to other member of the countries, whereas national treatment means treating foreign countries no less favorable than the domestic goods. This is non-discriminating value of the principle. And let us see about transparency, ensuring the trade policies and the practices are the clear and the public known. It should be very transferable to the public. And let us see about reciprocity. The reciprocity in the trade refers to the mutual exchange where the countries agree to provide each other with a comparable trade consensus or benefits. This means if one country lowers a tariff or reduces other trade business or import from another country, the other country will reciprocate by offering the similar concessions. Let us see about the rounds of negotiation. GATT opens through a series of trade negotiation rounds, each aimed to reduce the trade barriers. There was 8 rounds between 1947 to 1994, including the significant Kennedy round, Tokyo round, and Uruguay round. Kennedy round comes in 1964 to 1967, and the Tokyo round comes from 1973 to 79, and the Uruguay round is the most important round. It's come from 1986 to 1994. Let us see about the Kennedy round. This round focused on reducing the tariff and addressing the anti-dumping measures. Policies to prevent anti-dumping measure policies means it's to prevent foreign companies from selling goods at unfairly lower prices. And it is named after the US President John F. Kennedy. The negotiation resulted in significant tariff reduction and improved rules on anti-dumping. Let us see about the Tokyo round. Tokyo round starts from 1973 and to 1979, and this round mainly aimed to tackle the non-tariff barriers like quotas, subsidies, and standards, in addition to reducing the tariff further. It resulted in several agreements known as codes that deals with an issue of like government procurement, custom valuation, and the product standards, which help to the streamline and standardize international trade practices. And now the most important round is known as Uruguay round, and it's from 1986 to 1994. The Uruguay round was the 8th and the final round of the multilateral trade negotiation under the General Agreement on Tariff and Trade. It was the most comprehensive and the ambitious round, addressing a wide range of trade issues and signifies the shaping of global trade landscapes. Key aspects of the Uruguay round included the transition from the General Agreement on Tariff and the Trade of the World Trade Organization, which is known as WTO, marked as a pivotal evolution of the global trading system. This transaction brought a profound enhancement in trade liberalization. The comprehensive of the trade rules and efficiency of the dispute of the resolution mechanism by expanding its scope to include the services, intellectual property, and the investment measures. And the WTO created a more integrated and a comprehensive framework that reflect the complexities of modern international trade. Overall, the formation of the WTO the significantly advanced the goals of a open and the fair trade, fostering economic development and the cooperation among nations. The WTO continues to play a crucial role in the shaping of the future global commerce, building on a foundation laid at the GATT and addressing a new challenges and the opportunity in the evolving of a global economy. Let us see about the tariff reduction. Further reduction in tariff on industrial goods and the textiles was negotiated, facilitating the greater access of a market. And in agriculture, for the first time, agriculture trade was comprehensively addressed. The negotiation led to the reduction of agriculture subsidies and trade barriers, making agriculture markets more open and competitive. And in service, the General Agreement on the Trade in Service GATS was established, extending multilateral trade rules to the service sector, which includes areas like banking, insurance, and telecommunication. Let us see about the intellectual property. The trade related aspect of the IPR, intellectual property rights, it's TRIPS agreement was introduced, setting a minimum standard of protection and enforcement of intellectual property rights globally. Let us see about the dispute settlement. A more robust and restriction dispute resolution mechanism was created on improving the enforcement of trade rules and regulations. And TRIMS, which means trade related investment measures. The Trade Related Investment Measure TRIMS agreement was established during the Uruguay round of negotiations under the General Agreement of Tariff and Trade, which is known as GATT, and becomes a part of World Trade Organization WTO and framework. Then the WTO was formed in 1995. The purpose of TRIMS is to regulate the certain investment measures that to distort trade and negatively impact fair competition and the market practices. Trade related investment measures TRIMS are rules that apply investment policies of countries that affected trade in goods. These measures often involves condition or requirement placed on investors that can influence trade patterns. Let us see about the formation of the WTO. The Uruguay round culminated and signing of the Marrakesh Agreement in April 1994, which established the World Trade Organization. The World Trade Organization was established on January 1, 1995 as the result of the Uruguay Road negotiation under the GATT agreement. The formation of WTO marked as a significant milestone in the history of international trade, transforming and expanding the GATT framework into more comprehensive and robust institution. It promotes free trade by reducing the trade barriers and facilitate smooth international trade. It established trade rules and creating a consistent, transparent set of trade rules of members of country. And it resolves the trade disputes by providing a structural mechanism for resolving the trade disputes between one country to the another country. It has 164 countries as of 2024, representing over 98% of the global trade in the world. Key features of World Trade Organization. Let us see the institutional framework. The WTO provides a permanent institutional framework for the administration of multilateral trade agreements, making it a more structural and enduring organization compared to the GATT. And second one is broader mandate. Unlike GATT, which focused primarily on goods and a service, the WTO mandate includes the trade in service, GATT, and property rights as a TRIPS and investment measures as TRIMS. And the dispute resolution is a third one. The World Trade Organization has a more formalized and binding disputes settlement mechanism, ensuring that trade disputes are resolved fairly and efficiently. And the fourth one is Trade Policy Review Mechanism, TPRM. The World Trade Organization monitors and reviews the trade policies of members countries to ensure transparency and adherence to the agreed upon rules. And the fifth one is continuous negotiation. The WTO facilitate ongoing negotiation to further liberalize trade, address new trade issues and updating existing agreements. Let us see about the impact of transition of World Trade Organization. The transition from the General Agreement on Tariff and Trade to the World Trade Organization brought about a significant changes to the improvement in the global trading system. Here an explanation of the key impact of the transition. Let us see the increased trade liberalization as a first point as further reduction of trade barriers. The World Trade Organization facilitates the additional reduction in tariff and the other trade barriers beyond those achieved under GATT. This further liberalization helped to increase market values of goods and services and promoting more efficient and competitive market globally. More comprehensive trade rules. The WTO agreement encompasses a broader range of trade related issues, including services, intellectual property, and investment measures. This comprehensive approach has created a more integrated and cohesive global trade framework, addressing areas previously neglected under GATT. Let us see the fair and timely resolution of the trade disputes. The WTO introduces a more formalized and binding dispute settlement mechanism compared to the GATT. This system ensures that trade disputes are resolved fairly, impartially within a specified time frame, providing a greater predictability and stability in the international trade relation. Let us see the broader coverage includes services, IP, and the investment measure. The World Trade Organization mandate extends behind the traditional trade in goods to include the trade in the service. Let's get intellectual property rights and the trade related aspect of intellectual property rights as a trims and trade related investment measures are a trims. This broader coverage reflects the changing nature of a global trade and addressing the needs of the modern economics. I want to conclude here by that the transition from the GATT to the WTO marked a pivotal evolution in the global trading system. This transformation brought a profound enhancement in the trade liberalization, the comprehensiveness of a trade rules, and the efficiency of the dispute resolution mechanism. By expanding its scope to include services, IP, and the investment measure, the WTO creating a more integrated and cohesive framework that reflects the complexities of modern international trade. Overall, the formation of the WTO has significantly advanced the goal of open and fair trade. And fostering economic development and cooperation among nations, the WTO continues to play a crucial role in shaping the future of global commerce, building on the foundation laid by the GATT while addressing new challenges and opportunities in evolving the global economy. Thank you.
Good morning. My topic of presentation is India and WTO Contemporary Developments. The objective of this study, this presentation, is to explore India's evolving relationship with the World Trade Organization. So, in this presentation, we'll be looking into India's relationship with the WTO from the very beginning and recent trade disputes involving India, India's position in current WTO negotiations, and the critical evaluation of the same, then India's initiative at the WTO, and finally, we'll look into the future outlook. So let's begin with India's relationship with the WTO. So India has been a key player in WTO right from the start. On January 1st, 1995, India became one of the 123 signatories to the Marrakesh Agreement, which established the WTO. This wasn't just a formality, it signaled India's commitment to multilateral trading system and its ambition to help shape global trade laws. Now, what are India's key priorities at WTO? They fall into mainly three categories. Firstly, agriculture. So this is very crucial for India, as we all know, given its large farming population. India fights hard to protect its farmers and ensure food security. India pushes for reducing agricultural subsidies in developing countries and seeks permanent solution for this public food stockholding program. Secondly, services. So India is a powerhouse for services, especially in the field like IT. So it advocates for a greater market access and easier movement of professionals across borders. Thirdly, intellectual property rights. So here India calls out for balanced approach that considers developmental needs, particularly in areas like pharmaceuticals and traditional knowledge. So India doesn't just look out for itself, it often speaks up for developing countries too. It frequently takes leadership roles in WTO negotiations. We'll look into it later. India is also very active in WTO processes, in negotiation on issues like fishery subsidies, e-commerce, etc. But in essence, India's relationship with WTO is very complex yet so dynamic. It's about actively participating in and shaping global trade rules while also safeguarding economic interest and developmental needs of the countries. Now let's look into recent trade disputes. There are many trade disputes which involves India in WTO, but we cannot look into each and every one of them. So I'll be discussing three of the important trade disputes involving India. Firstly, the solar panel dispute. So, this dispute revolved around India's ambitious Jawaharlal Nehru National Solar Mission. As part of this initiative, India introduced domestic content requirements for solar cells and modules. So, in simple terms, India mandated that certain parts of solar power projects had to be made in India. So, the United States was not happy about this. They saw these requirements as unfairly discriminating against imported solar panels. So in 2013, they took their complaint to WTO, arguing that India was violating international trade agreements. In 2016, the World Trade Organization ruled in favor of United States. They found that India's domestic content requirements is indeed violative of global trade rules. The World Trade Organization essentially said that India was unfairly favoring domestic products over imported ones, which goes against the principle of non-discrimination in trade. So India of course appealed this decision, but in 2017 they lost the appeal. As a result, India had to remove these domestic content requirements by December 2017. So why is this case important? So it's a perfect example of the tightrope many countries walk in today's global economy. On one hand, India wanted to boost the domestic trade. On the other hand, they had commitments on the international trade agreements that limited how they could do this. So this case really highlights the tension between domestic industry policy and global trade rules. Now we look into ICT tariff dispute with EU and Japan. So India has raised tariffs on several information and communication technology products. These include items like mobile phones, base stations, integrated circuits, etc. So the European Union and Japan have taken this issue to WTO. They argue that by imposing these tariffs, India is violating its commitment to provide duty-free access to such products. This disagreement is not new, it's been going on for some time. In fact, a panel has been established in 2020 to examine complaints brought forward by EU and Japan. So India's counter argument is actually interesting. They claim that many of these products weren't actually covered by information technology agreement that they signed back in 1997. From India's perspective, the technological advancements have led to development of new products that fall outside the scope of that original agreement. So this case also highlights the challenges of applying older trade agreements to rapidly evolving technology sectors. So it also underscores the tension that can arise between promoting domestic industries and adhering to international trade commitments. Now we'll look into the sugar subsidies case. So in 2019, Australia, Brazil and Guatemala initiated a dispute against India at WTO, focusing on domestic support measures for sugarcane and sugar exports. These countries, being major sugar export, argued that India's support exceeded WTO limits and included prohibited export subsidies. So in December 2021, WTO panel found out that India's domestic support of sugarcane producers exceed the permitted level of 10% of total value production. The situation pressures India to reform its sugar industry policies, potentially reducing support to sugarcane farmers and sugar mills, while balancing domestic political pressures with international trade obligations. Now we look into India's position on current negotiations. So firstly, we'll look into agricultural negotiations. So India advocates for a permanent solution to protect its food security programs through public stockholding. The country seeks a lasting agreement that allows to purchase, stockpile and distribute food without facing challenges under WTO rules. Secondly, domestic support. So India defends its subsidies for small farmers, highlighting the crucial role in supporting millions of subsistence level farmers and ensuring national food security. Thirdly, special safeguard mechanism. India supports the creation of a SSM to protect against import sugars. This mechanism would allow India to temporarily raise tariffs to shield domestic farmers from sudden increase of import price in global market. Then market access. India seeks flexibility to maintain higher tariffs on certain sensitive agricultural products critical for its food security. Overall, India's position are driven by the need to ensure food security and protect small farmers. Now, India's position on e-commerce negotiations. So, India advocates for data localization to ensure data sovereignty and security. India also emphasizes the need for local storage processing data generated within India. Secondly, for data privacy, India put strong focus on protecting personal data and privacy and support regulations that safeguard citizens' data from misuse and breaches. Thirdly, for developmental concerns, India argues that global e-commerce rules should account for the digital divides and also account for flexibility and special provisions for developing countries. India's inclusive growth. India promotes policies that encourage domestic digital infrastructure and startups. It seeks to ensure that e-commerce benefit reach small businesses and rural areas. Now, for fisheries subsidies, India advocates for protection of small scale and artisanal fisheries. India emphasizes the importance of subsidies for livelihood of coastal communities, and also India supports the promotion of sustainable fisheries practices and calls for regulations that prevent overfishing and preserve marine ecosystem. India also argues for special and differential treatment for developing countries, and also there should be a balance in trade and development. India also calls for international support to enhance the capacity of developing countries. Now we'll critically evaluate the India's position in WTO negotiations. So firstly, on the pro side, these negotiations calls for protection of small scale and artisanal sectors and also for promotion of local manufacturing and industries through subsidies. India also gives focus to development and special differential treatment for developing countries and policies aimed at economic growth and poverty reduction. But on the other side of the coin, it put forwards many trade barriers. High tariffs and regulatory barriers can limit foreign investment, and protectionist measures may lead to trade disputes. The implementation challenges are also there. Difficulties enforcing sustainable practices and reforms, bureaucratic delays and infrastructure deficits also hinders policy effectiveness. Now we look into India's initiatives at WTO. I have listed out a few. Firstly, TRIPS waiver proposal, which is co-sponsored with South Africa for COVID-19 related medicinal products. Secondly, G33 proposal on food security. India is pushing for amendments to AOF for public stock holding. Thirdly, services domestic regulation. India has participated in various plurilateral negotiations. Trade facilitation for implementation of TFA commitments and capacity building. Lastly, developing country coalition. India is a very leading voice in G33, G20 and BRICS coordination, etc. Finally, we look into the future outlook. So first, the upcoming 30th Ministerial Conference. So India's priorities here include securing a permanent solution for food security programs, fair rules on fishery subsidies, and resolving the appellate body crisis. India aims to ensure that the conference outcome protect developing countries' interests. Regarding WTO reforms, India's envision is more of an inclusive and effective organization. This means giving developing countries a stronger voice, restoring the dispute settlement system, and ensuring that reforms prioritize developmental concern. Then on plurilateral agreements, joint India remain cautious. While engaging selectively based on its interest, India is concerned that these initiatives might undermine WTO multilateral nature and sideline developing countries' priorities. Climate change and trade is another crucial area. India supports environmental protection but insists that measures shouldn't become barrier to trade. Finally, in the realm of digital trade, India is working to shape rules that protect its growing tech sector and addressing digital divide. So throughout all these areas, we see that India balancing its role as an emerging economic power with the statute as a developing country. So India is consistently pushing for a more equitable global trading system that accommodates the development needs of all members. So as we move forward, India's engagement with WTO will continue to be crucial in shaping the future of global trade rules. So that's all for my presentation. Thank you.
I'm here to present you on the topic Dispute Resolution Mechanism of WTO. So basically the WTO's procedure is a mechanism which is used to settle trade disputes under the dispute settlement understanding. A dispute is said to be arising when a member government believes that another member government is violating an agreement which has been made in the WTO. However, these agreements are consequential to dialogues between the member states and hence they are the writers of such agreement. In case any dispute arises, the ultimate duty to settle it lies in the hands of member government through dispute settlement body. This system already achieved a great deal and providing some of the necessary attributes of security and predictability which traders and other market participants need, and which is called for in the dispute settlement understanding under Article 3. In this current presentation, I will be dealing with brief background of the mechanism, dispute settlement understanding, functions of the dispute resolution system and stages of the mechanism. Moving on to the brief background. From its inception of GATT in 1947, which is signed by the United States and ultimately by a total of 128 countries, provided for consultation and dispute resolution, allowing a GATT party to invoke GATT dispute settlement articles if it believes that another party's measure, whether violative of the GATT or not, caused it a trade injury. Because of the GATT did not set out a dispute procedure with great specificity, GATT parties developed a more detailed process including ad hoc panels and other practices. The procedure was perceived to have certain deficiencies, however, among them a lack of deadlines, a consensus decision-making process that allowed a GATT party against whom a dispute was filed to block the establishment of a dispute panel, and also the adaptation of panel report by the GATT parties as a whole, and laxity in surveillance and implementation of panel reports even when reports were adopted and had the status of an official GATT decision. Therefore, the Congress made reform of the GATT dispute process a principal US goal in the GATT Uruguay round of the multilateral trade negotiation, which began in 1986 and concluded in 1994 with the signing of the Marrakesh Agreement establishing the World Trade Organization, which is infamously called as the WTO agreement. The WTO agreement requires any country that wishes to be a WTO member to accept all of the multilateral trade agreements negotiated during the round, including the General Agreement on Tariffs and Trade of 1994, an updated version of the GATT adopted in 1947, as well as the understanding on rules and procedures governing the settlement of disputes applicable to disputes arising under virtually all WTO agreements. The Uruguay round package of agreements are not only carries forward original GATT obligations such as according goods of other parties, non-discriminatory treatment, not placing tariffs on goods that exceed negotiated or bound rates, generally refraining from imposing quantitative restrictions such as quotas and embargoes on imports and exports, and avoiding injurious subsidies. The agreement on the application of sanitary and phytosanitary measures, the agreement on anti-dumping, and the agreement on subsidies and countervailing measures. Congress approved and implemented the WTO agreement and the other agreement negotiated in the Uruguay round in the Uruguay Agreement Act. The agreement then came into force on January 1, 1995. Moving on to the DSU, which is also called the Dispute Settlement Understanding. It is officially known as the Rules and Procedure Governing the Settlement of Disputes. Establishes rules and procedures that manage various disputes arising under the covered agreement. There had been total 134 countries. There had been a total of 314 complaints brought by the member of WTO. All WTO member nation states are subject to it and are the only legal entities that may bring forth a case to the WTO. The Dispute Settlement Understanding created the Dispute Settlement Body, which is a DSB, consisting of all the WTO members, which administers dispute settlement procedures. It provides strict time frame for the dispute settlement process and establishes an appeal system to standardize the interpretation of specific clauses of the agreements. It also provides for the automatic establishment of a panel and automatic adoption of a panel report to prevent nations from stopping action by simply ignoring complaints. The strengthened rules and procedure with strict time limit for the dispute settlement process aim at providing 1. Security and predictability to the multilateral trading system and achieving solution mutually acceptable to the parties to dispute and consistent with the covered agreements. The basic stages of dispute settlement resolution covered in the understanding include the consultation, good office, consultation and mediation, appellate body review and remedies, which we will cover in the upcoming part of the presentation. Moving on to the functions of the dispute resolution system. 1. Providing security and predictability to the multilateral trading system, which is a central objective of the WTO dispute system, is to provide such security and predictability to the multilateral trading system by virtue of Article 3.2 of the DSU. Although international trade is understood in the WTO as a flow of goods and services between members, such trade is not typically not conducted by states but rather by private economic operators. The second function is preserving the rights and obligations of WTO members. Typically, a dispute arises when a WTO member adopts a trade policy measure that one or more other members considers to be inconsistent with the obligations set out in the WTO agreement. In such a case, any member of that to the part of the WTO that feels aggrieved is entitled to invoke the procedures and provisions of dispute settlement system in order to challenge that measure. The third function is relating to the clarification of rights and obligation through interpretation. The fourth one is mutually agreed solution as preferred solution. Although the dispute settlement system is intended to uphold the rights of the aggrieved members and to clarify the scope of the rights and obligations, this gradually achieves higher level of security and predictability. The primary objective of the system is not to make ruling or to develop jurisprudence. Rather, like other judicial system, the priority is settle disputes, preferably through a mutually agreed solution, which is provided under Article 3.7 of the Dispute Settlement Understanding. The next function is the prompt settlement of dispute. The DSU emphasizes the prompt settlement of disputes is essential if the WTO is to function effectively and the balance of rights and obligation between the members is to be maintained. It is well known that to be achieved, justice must not only provide an equitable outcome but also with swift. The next objective of DSU is the exclusive jurisdiction. By mandating recourse to the multilateral system of the WTO for the settlement of disputes by virtue of Article 23 of the DSU, it not only excludes unilateral action but also precludes the use of other forums for the resolution of a WTO related dispute. The next function is compulsory nature. The dispute settlement system is compulsory. All WTO members are subject to it as they have all signed and ratified the same as a single undertaking of which the DSU is a part. This consent to accept this jurisdiction of the WTO's dispute settlement system is already contained in a member's accession to the WTO. Moving on to the next, it is the stages of the mechanism. The first stage is consultation, which is provided under Article 4. The DSU permits a WTO member to consult with another member regarding measures affecting the operation of any covered agreement taken within the territory of the latter. If a WTO member requests consultation with another member under WTO agreement, the latter member must enter into consultation with the former within 30 days. The dispute is not settled within 60 days. The complaining party may request the panel. The complainant may request a panel before the period ends if the other members have failed to enter into consultation or if the disputant agrees that the consultation has been unsuccessful. The second stage on this regard is establishing a dispute panel. by virtue of Article 6 and 8, a panel request must be made in writing, must identify the specific measure at issue, and provide a brief summary of the legal basis for the complainant sufficient to present the problem clearly. Under GATT and now WTO dispute settlement practice, a member may challenge a measure of another member as such, as supplied, or both. And as such claim challenges a measure independent of the application in the specific situation and is described by the WTO appellate body, seeks to prevent the defending member from engaging in identified conduct before the fact. The panel is ordinarily composed of 3 persons. The WTO Secretariat proposes the name of panelists to the disputing party, which may not oppose them except for compelling reasons. If there is no agreement on panelists within 20 days from the date of such panel is established, either disputing party may request the WTO Director General to appoint the panel members. The next stage is panel proceeding, which is envisaged under Article 12, 15 and Appendix 3 of the DSU. After considering written and oral arguments, the panel issues a descriptive part of its report, which includes the facts and arguments to the disputing parties. After considering any comments, the panel submits this portion along with its finding and conclusion to the disputants as an interim report. Following a review period, a final report is issued to the disputing parties and later circulated to all WTO members. A panel must generally provide its final report to disputants within 6 months after the panel is composed, but may take longer if needed. Extensions are usual in complex cases. The period from panel establishment to circulation of panel report to WTO members should not exceed 9 months. In practice, panels have been found to take more than 13 months on average to publicly circulate reports. The next stage is appellate body review. The DSP, the Dispute Settlement Body, establishes a standing appellate body that will hear the appeals from panel cases. The appellate body shall be composed of 7 persons, 3 of whom shall serve on any one case. Those persons serving on the appellate body ought to be the persons of recognized authority with demonstrated expertise in law, international trade, and the subject matter of the covered agreements generally. The body shall consider only issues of law covered on the panel report and legal interpretation developed by the panel. Its proceedings shall be confidential and its reports anonymous. The next stage is adaptation of panel reports or appellate review under Article 16, 17 and 20 respectively. Within 60 days after panel report is circulated to a WTO member, the report is to be adopted at a DSP meeting unless the disputing party appeals it or the DSP decides by consensus not to adopt it. Within 60 days of being notified of an appeal, which is extendable to another 90 days, the appellate body must issue a report that upholds, reverses, or modifies a panel report. Unless a DSP decides by such consensus not to adopt it within 30 days after circulation to members, the period of time from the date the panel is established to which the date of the DSP considers the panel report for adoption is not to exceed 9 months. The 12 months in case of appeal it is 12 months, unless otherwise agreed by the disputing parties. The next stage is implementation of panel and appellate body reports under Article 21. In the event that the WTO decision finds that the defending member has violated an obligation under a WTO agreement, the member must inform the DSP of its implementation plans within 30 days after the panel report and any appellate body report as adopted. If it is impracticable for the member to comply immediately, the WTO decision, the member will have a reasonable period of time to do so. The member is expected to implement the WTO decision fully by the end of this period and to act consistently with the decisions after the period expires. The compliance may be achieved by withdrawing the WTO inconsistent measure and alternatively by issuing a revised measure that modifies or replaces it, which is the 7th stage in this process. The last is the remedies, which are the consequences for the members whose measure or trade practice is found to be violative of the covered agreement by a panel or appellate body. The dispute panel issues recommendations with suggestions of how a nation is to come with compliance with the trade agreements. If the member fails to do so within the determined reasonable period of time, the complainant may request negotiations for compensation. Within 20 days after the expiration of the reasonable period of time, if satisfactory compensation is not agreed, the complaining party may request authorization from the DSP to suspend the application to the member consent of concessions or other obligations under the covered agreement. This is a pictorial representation in which it shows the request for consultations, which is the first stage of the dispute settlement mechanism from the year 1995 to 2023. Thank you.